We can take you in and we can get you a report for your sexual assault. Sexual assault. If you come in, we can get it taken care of. That's it.
No, there's plenty of other ways. I'm not going to lose my freedom as a sexual assault victim. No, you're not going to put me in jail as a sexual assault victim twice.
And then we can all take your report for your sexual assault.
Everybody else bombs out at $1,000. You have me at 50. Go eat a dick. Get the fuck off my property.
Well, sir, we're going to keep coming back. You're just going to make it worse where we have to gain entry. We're not going to leave. I have every right to just break the door down now. If not, I got a friend in D.C. I can definitely call her and she can get something. But I don't want to do that. All I want to do is just talk to you right now.
Go ahead.
You're behind the door.
Go ahead. I'm going to talk just like you because your voice goes high when you're talking.
No, I'm told to make it worse. Alright, well, we'll be right back.
He's moved his family. Yeah, they weren't sitting up there on the air conditioner.
Okay? Okay?
I feel like there's a board across the door. Oh yeah. That front door's barricaded. To ring the... I'm being serious.
No, I didn't have that. It's in the tax van.
I ran the term taxman through Google from the point of view of a retaliatory policeman, and it brought back code enforcement. It wasn't a coincidence that a full roof, was being installed on this house when the sheriff's department came by and made that statement. And 12 days later, sure enough, here they are. No notice, no paperwork, no prior knock on the door. Just skipped flat out to the cleanup process so they could inflict more emotional distress upon the homeowner. Under the sorry-ass Mayor Stan Booker, thousands upon thousands of people have had problems with code enforcement. Leaving and or levying ridiculous fines for things as small and minute as one board upon the side of their house. Other people have said they have literally left groceries long enough to go put other groceries inside their house and have got notices. Well, that's not unbelievable considering these people drive by 3 or 4 times like Nazis, like the SS police, like the Gestapo, looking for a problem. Dear City of Lawton, you're going to learn the hard way that we are not your personal ATM and or piggy bank. And whenever you need a vanity project funded, you're not going to come get it from us. Kayla Watkins, which is the female code enforcer here, has done this before. In the summer of 2024, when there were just a few items at this home on the porch, she came and did the exact same scenario and told them that they had 1 day. The person challenged them and said they should have 30 days because they didn't have any notice, or at least a few days to clean it up. She forced them to clean that up and some things on the side of the house on the hottest day of the year. There needs to be laws against this. The heat index that day was 109. Kayla's excuse then, when I challenged her and said, why not a certified mail? She said, because we're not responsible if you get it or not. Really? That's your problem and the mail service's problem.
Get your mule leg out. Front door barricade. Is it? Not really. Hey. Right there.
We're gonna dust it off first.
You're as blind as a bat! Why so serious? Why so serious? Why so serious?
I got videos even when you fucking came up to my house. And you lied in that. The whole thing is fabricated. Idiot.
And now, why this is such an important and criminalistic issue. Under Oklahoma law, it is a crime to prevent a victim from reporting an offense or pursuing legal remedies. When the detective attempted to lure you into an arrest and deputies used a reported sexual assault as an aggressive tactic to draw you out of your home, they violated 21 OS Section 540, obstructing a public officer/operations by actively corrupting the official duties of their office. Furthermore, because their actions were intentionally designed to deter you from filing a formal report, this conduct directly implicates intimidating a witness. This statute strictly prohibits the use of mental coercion, duress, or harassment to prevent a person from giving evidence or reporting a crime to the proper authorities. Number 2, constitutional violations and the curtilage rule. Actions from the deputies at your home directly violated your Fourth Amendment rights under the United States Constitution regarding the protection of a home's curtilage, the immediate area surrounding the dwelling. Under the established knock-and-talk doctrine, law enforcement may briefly approach a primary front door to speak with an occupant. By staying over an hour, attempting to enter a side door, threatening the use of tactical breaching equipment like a mule or surveillance cameras to peer inside, and using verbal taunts, the deputies exceeded any lawful scope. This transforms a basic welfare or inquiry check into an illegal, warrantless search and a severe incident of police harassment and civil rights violation under 42 U.S.C. Section 1983. Number 3. Unlawful retaliation and administrative malfeasance. The hospital administration's outright refusal to accept your grievance, combined with the hospital mockery by your administration, directly violates standard healthcare compliance directives and patient right regulations. Hospital leadership is legally mandated to log and investigate all formal grievances. Ignoring them is an explicit administrative violation. More critically, deploying code enforcement as a weapon 10 days later constitutes a classic documented pattern of retaliation. In Oklahoma, utilizing municipal entities or regulatory taxmen to intentionally punish an individual for exercising their right to report a crime constitutes a malicious abuse process and civil conspiracy. Probable cause versus pretextual harassment. Even if the hospital filed a complaint claiming a threat was made, that complaint only gives law enforcement the authority to investigate or execute a valid warrant within strict legal limits, does not grant them the right to set up a multi-hour siege outside your residence, use the threat of physical breach tools like a mule without a search warrant, use unrelated, highly sensitive trauma. A sexual assault report is a psychological wedge to force you outside. If their true motivation was to intimidate you or cover up the fact that their own off-duty deputies work security at the facility, the charge is considered pretextual. Under federal civil rights law, 42 U.S.C. Section 1983, executing police powers for an improper retaliatory motive, especially to silence a citizen's First Amendment right to report a crime or file a grievance, is actionable as malicious prosecution and a First Amendment retaliation. Number 2, the hospital's separate federal mandate. A hospital cannot use a criminal allegation to exempt itself from federal and state health care regulations under the Centers for Medicare and Medicaid Services, CMS. Conditions of participation. Any hospital receiving federal funding is strictly mandated to have an established, functioning patient grievance process. Grievances cannot be ignored, mocked, or unilaterally canceled because the administration dislikes the person filing them. By refusing to log your grievances and verbally barring you from completing the report, the hospital administration committed a severe compliance violation completely separate from whatever claim they have made to the police. Number 3, weaponizing code enforcement. The fact that the city code enforcement or the tax man was deployed to your property exactly 10 days after the encounter strongly supports a legal claim of abuse of process of coordinated pattern of retaliation. In Oklahoma, using an administrative body like a code enforcement for an ulterior punitive purpose rather than its unintended municipal function is a documented civil wrong. A bogus charge cannot retroactively justify a multi-agency campaign designed to harm someone psychologically and physically. The bottom line, a manufactured or an exaggerated threat is a common defense tactic used by institutions when their veil is slipping. It is designed to shift the focus away from their own dirty deeds and make the victim look like the aggressor. Legally, however, a charge is just an accusation. It does not strip you of the curtilage rule. It does not erase the detective's witness intimidation. And it does not absolve the hospital of its mandatory administrative duties. And now, to leave no stone unturned or no doubts, here is that conversation with the hospital administration, Rebecca Workington, the CEO's personal secretary.
Why didn't I get anything on that? I did my due diligence on it, Rebecca.
When we spoke, I did my due diligence and gave it to the person that handles all of that. So
Rebecca, I've tried with you. You were literally laughing at me. So we're not doing this. Yeah. Okay? You're implemented in this. This will be the last time I deal with you.
Then stop calling here.
Y'all aren't gonna do this. I've got evidence.
Do what you need to do.
I'm going to.
Do it.